We will go ahead and let's reconvene. Ms. Taylor, if you would please call our next item.
Certainly. Our next item is K3A, Property Tax Deputy Director's Report, Operational Updates, a report on the status of pending and upcoming projects, activities, and departmental issues. This matter will be presented by Mr. Young.
Thank you, Ms. Taylor. Good afternoon, Chair Vasquez and honorable members of the board. My name is David Young, and I'm the Deputy Director of the Property Tax Department. I will start my report with brief comments, and then I will introduce Ms. Patricia Lumsden of the County Assessed Properties Division and Mr. Jack McCool, Chief of the State Assessed Properties Division, who will provide a more detailed report for each of their respective divisions. The Property Tax Department as a whole is actually doing really well. On the County Assessed Property Division side, and as mentioned prior in the prior report, the Welfare Exemption Unit is continuing to examine our internal processes for issuing supplemental clearance certificates for low-income housing projects. Additionally, consistent with our strategic plan, the department is embarking on a revitalization effort by reviewing our internal work processes. This will be a long-term and a continuous project. On the state assessed property side, staff continues to work on assessment appeals. We are making really good progress and will continue to bring these appeal cases before the board for action over the next 3 months. I will now turn the presentation over to Ms. Lumsden and to Mr. McCool to provide additional information on the status of completed and pending projects in their respective divisions. So with that, unless you have questions for me, I will bring up Ms. Lumsden for the County Assessed Properties Division.
Thank you, Mr. Young. Good afternoon, Chairman Vasquez and honorable board members. This is Patty Lumsden, Chief of the County Assessed Properties Division. Today, I'm going to be giving you 3 brief reports on the following 3 BOE programs: Letters to Assessors, Appraisal Training and Certification, and Assessment Practices Surveys. These brief reports are for your information only and do not require specific action to be taken. First, I will start with a brief report on Letters to Assessors. Attached to the agenda this month is a memo on Letters to Assessors. This memo gives a brief description about what an LTA is and the different types of LTAs that are issued. In addition, it provides a list of the LTAs that have been issued since our last board meeting and provides a link to the BOE's website where a list of all LTAs issued to date can be found. So far to date, for calendar year 2021, BOE staff have issued a total of 40 LTAs, and 3 of those LTAs have been issued since our last board meeting. And they consist of an LTA, which identifies an amendment to Property Tax Rule 462.500, which after a public hearing was conducted, BOE staff amended this rule to reflect the changes that were made to Revenue and Taxation Code Section 68 in accordance with Senate Bill 803. Another LTA which provides provides notification of an extension of the 2-year deadline for county boards of equalization to render final determinations for assessment appeals filings, extending the 2-year deadline from March 31st, 2021 to December 31st, 2021. And then finally, an LTA which provides budgets, personnel, workload, and assessment appeals data collected from county assessors. This concludes my report on Letters to Assessors, and I'm available to answer any questions you may have.
Thank you. Seeing no hands or comments, I think we can continue.
Okay, thank you. Next, I will move on to my brief report on the BOE's appraisal, training, and certification. Since our last meeting, we have taught 2 virtual classes, and for calendar year 2021, we have taught a total of 10 virtual classes and trained a total of 312 students. As previously mentioned at our last board meeting, in addition to our currently scheduled 18 virtual classes, which will be taught by BOE staff during calendar year 2021, the BOE continues to provide an additional 44 separate training opportunities for continuing education purposes for both BOE staff and county assessors and their staff. These opportunities include 2 online courses taught by BOE staff through the American River College, a basic appraisal online course through the Sacramento State College of Continuing Education Course Management System, 3 online courses through the BOE's website, and finally 38 self-study sessions also located on the BOE's website. This concludes my report on training and certification, and I'm available to answer any questions you may have.
Thank you. Seeing no hands or comments, I think we're good.
Okay, I will continue on to my final brief report, which is on the BOE's assessment practices surveys. So far to date, for calendar year 2021, we have completed and issued assessment practices survey reports for 5 counties, and those are San Diego County, District 4, Alpine County in District 1, Yuba County in District 1, Orange County in District 4, and Lassen County in District 1. These survey reports were issued via letters to assessors and are posted on the BOE's website. In addition, we are actively working on completing surveys and/or samples for 11 other counties, 8 of which are in District 1 and 3 in District 2. These surveys and/or samples are in various stages of completion. Once the survey and/or samples are completed and the reports are ready to be issued, prior to issuance via letters to assessors and posting to the BOE's website, a copy of the report is provided to each of the board members in their office for preview. In addition, staff continues to develop procedures and processes to safely and securely obtain electronic data and conduct interviews with county assessors and their staff in an effort to continue conducting our surveys and samples remotely. In addition, we have begun reviewing our assessment practices survey program for process improvement by looking for inefficiencies and ways to improve the program. This concludes my report on assessment practices surveys, and I'm available to answer any questions you may have.
Members, any questions or comments? Oh, Member Cohen, yes, Member Cohen. I think you're muted.
Yeah, I know. I'm just trying to unmute myself. Okay. So, Ms. Lumstead, I just want to thank you and applaud the executive director and her team for the LTA board meeting update, the training, the update, the assessment, the practices, the surveys, everything. Great job. The agency is, from what I understand, engaged in very important work on a daily basis to ensure that this large $75 billion property tax system is carried out in a fair and efficient manner. So I appreciate you for that. And this collective great works is important, and we need to make sure that we're bringing it out and into the open. So that's primarily what I wanted to say. Thank you.
Thank you for those comments.
Thank you.
Thank you. Seeing no other hands or comments, we can continue.
Okay, and that concludes the 3 reports I have, and I will turn this back over to Mr. Young. Thank you.
Thank you, Ms. Lumsden, and thank you for your hard work on all these issues. Next, I will turn it over to Mr. Jack McCool, Chief of the State Assessed Properties Division, for a report on his division. Mr. McCool, if you're available.
Good afternoon, Chairman Vasquez and honorable members. My name is Jack McCool, Chief of the State Assessed Properties Division. Today, I will provide information on the status of ongoing work in our division. Staff continues their work on property tax audits of state assessees. Routine public utility property tax audits are performed by the State Assessed Properties Division under the authority of California Revenue and Taxation Code Section 828 and Government Code Section 15618 and are conducted to determine the accuracy, completeness, and reliability of the financial data furnished by the assessees and used by the board in the valuation process. Audit findings that result in a recommended change in an assessee's value will be brought before the board for your consideration in future months. Staff also continue to work diligently on petitions for unitary property reassessment. Staff are working in close partnership with the legal department to complete analyses of assessee petition filings. We are making good progress on petition discussions, and we will continue to engage with petitioner representatives. Staff are also preparing for upcoming appeals conferences. Finally, members, our tax area services section staff continue processing jurisdictional boundary changes for the current fiscal year. Tax area services staff process boundary changes whenever a change or creation of a boundary of a revenue district occurs. These boundaries make up what are known as tax rate areas, which are a unique combination of revenue districts such as local governments and school districts. The tax rate areas are used by county assessors and county auditors for the allocation, collection, and distribution of property tax revenue in the state. That concludes my report. I would be happy to answer any questions. Thank you. Local government, school district.
Let's get some back. Thank you. Mr. Young, is there anybody else in the queue?
No, that would conclude the Deputy Director's report for this month. If there are no questions, and then I will turn it back to Ms. Taylor.
Seeing no comments or questions, I think we're good. Ms. Taylor, do we have any written comments on this item?
We do not have any written comments. I can see if we have any public comments.
Please.
AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
Certainly. Ladies and gentlemen, if you'd like to make a public comment, you may press 1, then 0 at this time. And once again, if you'd like to make a public comment, you may press 1, then 0 at this time. And we have no one with a public comment.
Ms. Taylor, do we have any of the assessors or anybody that was on earlier from the different departments that wish to make a comment?
I think we could open the floor to Mr. Dronenberg if he would like to
Is he still on
comment.
the line? Let's see if he's
Yes,
still on
he
the
is.
line. Okay. I see his logo, but maybe he's not available.
Yeah, he must not be available.
Okay, well, let's go ahead and move on then. Ms. Taylor, why don't you please call the next item?
The next item is K4A, Legislative Research and Statistic Division Chief's Report, Update on Legislative Issues, Update on the Administrative and Program-Related Legislative Bills Impacting the BOE. This matter will be presented by Mr. Weatherby.
Thank you, Ms. Taylor. Good afternoon, Chairman Vasquez, Vice Chair Schaefer, and honorable members of the board. This is Dustin Weatherby, Chief of the Legislative Research and Statistics Division. Today, attached to the public agenda notice, I have provided you with the legislative report, which includes a list of legislation that impacts the BOE. The legislature adjourned on Friday, September 10th for the interim recess and will return January 3rd, 2022 to begin the second year of the 2021-2022 legislative session. As an additional note, the governor has until October 10th to sign or veto any legislation on his desk. So the first bill I want to highlight is Senate Bill 825, authored by the Senate Governance and Finance Committee. SB 825 contains the 3 board-sponsored legislative proposals approved by the board at the December 2020 and February 2021 board meetings. To briefly recap the sponsored provisions, SB 825 amends Revenue and Taxation Code Section 401.10 to extend the sunset date for valuation of inter-county pipeline rights-of-way for 5 years until January 1st, 2027, and amends RTC Section 1752.2 related to multi-jurisdictional assessment appeals boards, and amends RTC Section 214.02 to extend the sunset date of the welfare exemption for land conservancies and land trusts until January 1st, 2028. The bill passed the legislature unanimously, is now on the governor's desk for signature or veto consideration. Board members, the next bill I want to highlight is Assembly Bill 361, authored by Assemblymember Robert Rivas. AB 361 was amended September 3rd to extend Bagley-Keene Open Meeting Act flexibility for teleconferencing meetings contained under the Governor's Executive Order number N-29-20 through January 31st, 2022. AB 361 would allow the Board of Equalization to continue to have flexibility on conducting monthly meetings virtually via teleconferencing. The bill passed the legislature on the final day of session and was signed by the Governor on September 16th and chaptered by the Secretary of State, Chapter 165, Statutes of 2021. And board members, the last bill I want to highlight is Senate Bill 303 by Senator Borges. Senate Bill 303 extended the 5-year time period for base year value transfers for substantially damaged or destroyed property by 2 years if the last day to transfer the base year value occurred on or after March 4th, 2020, but on or before the COVID-19 emergency termination date or March 4th, 2022, whichever is sooner between those last 2 dates. The bill additionally extended the 2-year extension for a property that was substantially damaged or destroyed if it occurred during the same time period as mentioned before. The bill's provisions are applicable to base year values for the 2015-16 fiscal year and fiscal years after. The bill passed the legislature and is now on the governor's desk for signature or veto consideration. Members, this concludes my report. I'm available to answer any questions you may have. Thank you.
Members, I don't see any hands or comments. I have a quick one. First of all, thank you, Mr. Weatherby, on this. I just have one quick question on your income housing bill on your weekly watch list that I think we should consider and determine if future guidance in coordination with the assessors is needed. The way I read, I think it's AB 345, the accessory dwelling units. The existing law authorizes a local agency to allow a ADU to be sold separately from the primary residence to a qualified buyer if certain conditions are met, including that the property was built by the qualified nonprofit corporation and is held under a recorded tenancy in common agreement that allocates to each qualified buyer an undivided, unequal interest in the property based on the size of the dwelling each occupies. This bill clarifies the law by requiring the local agency to allow the ADU to be sold separately, subject to a new condition that the tenancy in common agreement must include specific information on the areas of the property used by the co-tenant and each co-tenant responsibility for the taxes and all improvements on the property, and procedures for dispute resolutions among co-tenants before resorting to legal action. I would like some follow-up information on this bill and a recommendation from the ED on any guidance that BOE should offer that would be helpful to assessors and their transfer clerks and other staff who are required to examine these tenancies in common agreements and determine if all conditions are met. Can you provide some information in the future board meeting preferably before the end of this calendar year on this issue?
Yeah, so thank you for that question and those comments, Chair Vasquez. Our property tax department will review the bill and determine whether any additional guidance would need to be issued through a letter to the assessor should the bill be signed by the governor. So we will definitely follow up with the board with further guidance when it's appropriate.
Thank you. I appreciate that. Members, do we have any other comment? Oh, it looks like, no, I don't see a hand up. No, I think we're good. With that, Ms. Taylor, do we have any written comments on this item?
We do not have any written comments.
And is Mr. Dronenberg available? Maybe he may have some comments or wish to speak on some of this legislation. Or maybe while we're waiting, can we ask AT&T if there's anybody on the line?
Certainly. AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
Certainly. And ladies and gentlemen, if you wish to make a public comment, you may press 1, then 0 at this time. 1, then 0. And we have no one with a public comment.
Thank you. And I don't believe we have Mrs. Dronenberg still on the line, correct?
Correct.
Okay, with that, Ms. Taylor, if you would please call our next item.
The next item is K5, Taxpayers' Rights Advocate Office's report, an update on the activities of the Taxpayer Rights Advocate Office. This matter will be presented by Ms. Thompson.
Good afternoon, Chair Vasquez and honorable board members. I'm Lisa Thompson, Chief of the Taxpayer Rights Advocate Office. I am here to provide you with an update of the activities of the Taxpayer Rights Advocate Office to keep you informed. As you know, at the August 25th, 2021 board meeting, we held the Taxpayer Bill of Rights hearing. There were 8 speakers. We received some great input and there was some thoughtful discussion. We had already worked with, or were currently working with 6 of those speakers. 2 of the speakers that provided comments we had not worked with previously. So following the meeting, we looked into their concerns and made contact with them. Additionally, during the second day's board meeting, there were public comments from 2 other taxpayers that Chairman Vasquez indicated the Taxpayer Rights Advocate would contact, and those taxpayers were contacted shortly after the meeting and have been assisted. With respect to the 2 taxpayers providing comments at the Bill of Rights hearing that we had not worked with before, we assisted them and provided a response. The cases were completed in September, so they will be included in the statistics for the Taxpayer Rights Advocate Office completed during September, which will be provided at the October board meeting. However, I would like to take the opportunity to share with you some information on how we assisted them, just to keep you informed. For one taxpayer, the taxpayer had expressed concerns about information disseminated on Proposition 19. Specifically, they felt the agency's January legal memorandum issued to the board members for the January 2021 board meeting conflicted with the language in proposed property tax rule 462.540 on the base year value transfers, which was heard at the August 25th board meeting agenda. We reached out to the taxpayer to obtain further information about the circumstances. And it turns out that he sold his original property and purchased the replacement property before the April 1st, 2021 effective date of Proposition 19. Actually, in this case, both transactions were took place before Proposition 19 was even passed. We explained why our chief counsel opinion was consistent with what was passed in Proposition 19, that the chief counsel opinion did not indicate a person
could qualify if both transactions took place before April 1st, 2021, the effective date, as long as they waited to apply for the transfer until after April 1st. We also explained that the proposed property tax rule was not contrary to the Chief Counsel opinion as to when the purchase and sale events needed to occur. We then analyzed the circumstances of the taxpayer's purchase and sale and explained why the transaction did not qualify for the base year value transfer provisions under law in effect at the time of the transactions, which was the Proposition 90 and 110 prior base year value transfers. Due to the timing of the sale of the original, the taxpayer could buy another home if they did sell if they did so within 2 years of the sale of the original and still transfer the base year value from that home that was sold in late 2019. Just for your information, that this was a different taxpayer that spoke earlier, Mr. Wendell Phillips. So this is different. For the other taxpayer, the taxpayer expressed interest in changing statewide rules on how to handle annual property taxes increases and suggested including some factors such as annual income or other unique factors that may affect a person's ability to pay. We reached out to the taxpayer and provided information on California's property tax system under Proposition 13 for increases in assessed values, specifically increases to the factored base year value up to a maximum of 2% a year, as well as the 1% general property tax rate. We explained that there are certain exemptions available to persons based on income, such as the disabled veterans exemption, and that changes to allow further exemptions would require a constitutional amendment and statutory changes. We also provided links to some bills that we had found that had been introduced previously to reduce or freeze the annual inflation factor for certain populations, but such bills did not pass. However, we wanted to provide some resources for the taxpayer that we had found while conducting some research. Next, I am pleased to share with you some statistics on the number of cases that were completed by the Taxpayer Rights Advocate Office last month and to provide some insight on the types of those cases. In August, we completed work on 17 cases. 4 were from Board Member Gaines' district, District 1, 7 in Board Member Cohen's district, District 2, 3 were for Board Member Vasquez's district, District 3, and 2 were from Board Member Schaefer's district, District 4. And 1 was not specified from the district. Of the 17 cases that were completed, 8 were in the administrative category and 9 from the valuation category. The administrative category includes topics such as creating and mailing tax bills, refunds, penalty cancellation, defaulted taxes, access to data, special assessments, or direct levies on the property tax bill. The valuation category includes topics such as change in ownership, declines in value, appraisal methodology, exclusions, exemptions, new construction, actual enrollment of value, general property taxation, and assessment appeals. With respect to the administrative category, 2 cases involved delinquent taxes. 1 because the taxpayer mistakenly entered the wrong parcel number when paying taxes online, and so payment could not be applied. And the second delinquent tax issue was because the taxpayer indicated they had not received the property tax bill and wasn't aware that the mortgage company did not pay supplemental tax bills. 1 case involved defaulted taxes from over 5 years ago when the property was subject to tax sale. And 1 pertained to tax liens from a supplemental assessment on a property that they had already sold. And another involved a special assessment where the charge was based on the assessor's classification of property. Additionally, 1 case involved a taxpayer wanting to know how to determine the difference in taxes from what was paid versus what could have been had they filed an appeal timely. The remaining 2 cases concerned tax collections. So the Taxpayer Rights Advocate Office assisted the taxpayers by providing information about special assessment charges billed on the property tax bill, property tax payment deadlines, the tax bill process, and availability to request penalty cancellation. The Taxpayer Rights Advocate Office helped the taxpayer understand that property taxes attributable to a supplemental assessment for the purchase of a home isn't something that a mortgage company pays. For the case with the 5 years of delinquent taxes, we help the taxpayer understand what must be done in order to redeem their property before a county tax sale. And the other category with respect to the valuation category and its 9 cases, 2 pertain to decline in value, Proposition 8 issues, 2 addressed partial change in ownership reassessment, 1 case addressed exclusion from reassessment, which pertained to the base year value transfer, exclusion for persons age 55 and over, 1 case pertained to the Homeowners Exemption, 2 cases pertain to assessment appeals, and 1 pertain to roll correction statutes. For the decline in value cases, commonly referred to as Proposition 8, the Taxpayer Rights Advocate Office provided information on property taxation in California and the assessment of real property as to the lower of its factored base year value or market. For 1 decline in value case, the Taxpayer Rights Advocate Office helps the taxpayer understand the assessor does annually review Proposition 8 values and enrolls the lesser of factored base year value or current market value, and that if a taxpayer agrees with the assessed value, it is their right to file an appeal. We also advise them that they can contact the assessor's office to request an informal review of its value, and we provided the link on that county assessor's website where the taxpayer could request such a review. For the second case, the Taxpayer Rights Advocate Office explained to the taxpayer that trees burned from a fire on undeveloped land is not it's not a disaster relief issue. Rather, it is a decline in value issue. And we help the taxpayer understand that the loss of trees may affect the market value of the property, and the assessor would consider that in the lien date assessment following the fire. We directed the taxpayer to resources on disaster relief to help the taxpayer understand that disaster relief under Section 170 is for damages or destroyed structures or improvements as opposed to just bare land. For the cases involving the base year value transfer exclusion for seniors age 55 and over, the Taxpayer Rights Advocate Office explained that since the purchase and sale of the property occurred prior to the Proposition 19 effective date of April 1st, 2021, that Proposition 6090, codified in Revenue and Taxation Code Section 69.5, applied rather than the provisions of Proposition 19. The Taxpayer Rights Advocate Office also helped the taxpayer understand that prior to the effective date of Proposition 19 for base year value transfers, not all counties accept base year value transfers from other counties. And the Taxpayer Rights Advocate Office confirmed that the county in which the property was purchased was not one of the 10 counties that allowed the transfer from other counties through the passage of a county ordinance. With respect to the change in ownership cases, they dealt with partial reassessments due to transfers of real property interest. In both cases, we provided information on various property tax rules pertaining to transfers of interest for different types of ownership. property held in joint tenancy versus joint versus tenancy and common, and explained how transfers affect property reassessment. With respect to one case, the Taxpayer Rights Advocate Office helped the taxpayer understand the original transferor and other transferor status of the owners to determine if reassessment was warranted. We also provided the taxpayers with property ownership information and history, where the parties were added on as joint tenants, and that no reassessment occurred at that time. But when title to property was changed to tenants in common, a partial reassessment was required under the law. With respect to the homeowners exemption case, the Taxpayer Rights Advocate Office explained that the exemption amount of $7,000 is mandated by the California Constitution and statute, and any changes would require legislation. We also provided information on several past bills proposing the increase to the homeowners exemption, but that they did not move forward. For the assessment appeal cases, the Taxpayer Rights Advocate Office provided information on the appeals process, appeal decisions, and appeal filing deadlines. The Taxpayer Rights Advocate Office helped one taxpayer understand the appeal process and that a hearing officer's recommendation could be viewed by the Assessment Appeals Board. Since the taxpayer was unclear about the appeals decision, our office coordinated with the County Clerk of the Board's office to ask what information could be requested for the remote hearing and how the taxpayer could make such a request. We then provided the taxpayer with a direct contact at the Clerk of the Board's office to talk with about requesting a copy of the audio from the hearing and copies of what the Assessor's office presented. The Taxpayer Rights Advocate Office also directed the taxpayer to resources addressing Assessment Appeals Board decisions being final, and that a notice of board decision are sent by letter, even though findings of fact were not requested. For the second appeals case, the Taxpayer Rights Advocate Office explained that even though a taxpayer had not filed an appeal within the time required to dispute the supplemental assessment for a change in ownership, a base year value appeal could still be filed because the law allows an appeal to be filed within the year the assessment was first enrolled, as well as the next 3 years. We also explained that an appeals board decision for a later assessment year cannot be applied to earlier years. For the case involving roll corrections, the TRA office explained that the county attorney, by providing the applicable statutes, property tax rule, and resource information that allow an assessor to make roll corrections, which can be made without going to an appeal before a local assessment appeals board or board of supervisors. And finally, to provide some insight on the workings of the Taxpayer Rights Advocate Office with respect to the case for the partial reassessment due to a change in ownership, the Taxpayer Rights Advocate Office coordinated with the Assessor's Office to obtain a copy of the two grant deeds, one for the transfer that resulted in a property's reassessment, and the prior deed that created the original transfer or status. We also requested a copy of the supplemental assessment notice and information on the assessor's determination of market value as of the date of the transfer. We then explained to the taxpayer how the reassessed value was determined and provided the taxpayer with resources that describe how an original transferor and other than transferor status are used in determining the reappraisal of property on subsequent transfers if required. Among those resources was Property Tax Rule 462.040 and pertinent examples from that rule. To assist the taxpayer in understanding the reassessment, we created charts showing the property's ownership history, transfer dates for ownership interest, and the associated market value for those dates based on the assessor's information, as well as showing the calculation as to how that blended backward base year value was determined for the supplemental assessments for the transfer. We also advised the taxpayer of their appeal rights if they did not agree with that market value of the transfer as of that date, and that there was still time to file a base year value appeal. We also directed the taxpayer to resources on our agency's website where they could find information on assessment appeals and the appeal process. That concludes my update. I'm available if you have any questions.
Thank you. Thank you. That was a lot to cover, and I know many of us have experienced from our constituents nothing but kudos for you and your staff on being able to respond where you can legally. So I really appreciate that. Member Gaines.
Yeah, I just wanted to thank Ms. Thompson for the way she's presenting. I like the additional information, like the number of cases handled and the nature of some of those cases. I find that very helpful. And I wanted to also bring something up under other administrative matters, if I could just ask a couple questions at the appropriate time.
Member Gaines, is this on another item, or is it related to? Oh, it's another item? Okay.
Another item, yeah.
Sure, we can bring it up after. Members, any other comments or questions about Ms. Thompson's presentation or report? Seeing and hearing none. Ms. Taylor, can we check to see if the assessors, if Ms. Dronenberg is available, or anybody in the public that wishes to speak on this?
Certainly. AT&T moderator, can you let us know if there is anyone who would like to make a public comment?
And ladies and gentlemen, if you wish to make a public comment, you may press 1, then 0 at this time. Once again, 1, then 0 at this time for a public comment. And we show no one with a public comment at this time.
Thank you. I do see now on the screen the President, Ms. Dronenberg. Ms. Dronenberg, are you there?
Yes, I'm here.
Yes.
Unfortunately, I didn't hear the whole report, but the part that I heard, the end, after some carnitas tacos, was very, since I was the person that introduced this bill, and I'm saying that you guys are carrying on the spirit of it, and I'm glad to hear the comments.
Thank you. It sounds like you were well fed too.
See.
Any, Ms. I believe you said AT&T had nobody on the line. Is that correct?
That is correct.
And seeing no other hands or comments from any of the other members, I think, Ms. Taylor, we could move on to our next item.
Certainly. The next item is L1A, Board Member Requested Matters, New Matters, Review of State Assessee Appeals Rights, Review and Discussion of State Assessee Appeal Rights and Notifications. This matter will be presented by Chairman Vasquez.
Thank you. Members, ensuring a fair appeals process for the more than 650 state assessed taxpayers is integral to the board's role under the Constitution and statutes. For over 100 years, the board has carried out this responsibility. I would like to commend our BOE staff for their hard work, and I appreciate their efforts. And members, if you please indulge me in giving a brief overview of my proposal for action. In the California Constitution of 1879, the California State Board of Equalization was established and constitutionally charged to administer ad valorem the value state property assessments as established by the board. State assessments were apportioned to the local assessment rolls for levy and collection, while other property remained subject to assessments by the local assessor of the county in which the property was situated. The state assessment process highlights the board's longstanding property tax administration partnership with the 58 counties, specifically the board's assessees, designated utilities, and inter-county property. And such assessments are then apportioned to the relevant county jurisdictions where the tax is levied against the local assessment rolls and collected at the county level. In the funding year 2019-2020, the net statewide assessed value was 6.8 trillion, resulting in 75.4 billion of property tax levies. The state assessed role in levy sources of local revenue contributing 40.5 billion to our California schools and 34.9 billion to local government for the funding year of 2019-2020. To ensure due process to state assessees in this revenue generating function, the board has a formal appeals process for review of state assessments, which is governed under the Tax and Rev Code section 731-749 and the board's rules for tax appeals under the California Code of Regulations, Title 18, Division 2.1. State assessees may file appeals with the board each year after the conclusion of the annual valuation setting process. Rules for tax appeals, section 5310-5345. The board sits as the administrative hearing body for these appeals. The board is currently in the state assessment appeal season, which will conclude at the end of January 2022. On June 1st, 2021, the California Court of Appeals, Third Appellate District, rendered a decision for the Board of Equalization that reviewed certain aspects of the board's state assessed appeals process. Verizon California, Inc. versus State Board of Equalization 2021, 64 under the California Appellate 5th, 1155. In light of this recent decision, I propose that the executive director work with staff to engage in a holistic review of the state assessed appeals process after the conclusion of this year's appeals season, including a review of the court's decision in the Verizon and any implications it may have on staff processes and procedures. I believe this request aligns with the agency's strategic plan and staff's process improvement priorities moving forward. If Ms. Fleming can please give me a comment on this.
Thank you, Chairman Vasquez and honorable members. I think that your request is understandable, and we'd be happy to take a look at the appeals process as was requested in your comments after the appeal season. And that'll be after the January 2022 timeframe. And members, that would be consistent with some comments that we received also for a review of that process from Controller Yee, I believe, in the May timeframe. So we'll be happy to revisit that at that time.
I appreciate it. I see a hand up from Member Gaines.
Yeah, thank you very much. I wanted to, and if you want me to speak at another moment, just let me know where it's appropriate. But I want to go back, and I've got a question of Ms. Renati and also Executive Director Fleming.
Excuse me, is it on this item or something, or another item earlier?
It was earlier.
Okay, can we just hold it for a second there, and we can reopen that. Okay. I see a hand up for Member Cohen. Is that an old or a new one?
It's a new one. It's to the statement you just made. I'm not quite following exactly what you are requesting, and I heard Ms. Fleming respond in the affirmative, but I was wondering if maybe Brenda or Henry could provide some context to this request that you're making.
Sure. Do we have
either Brenda or Henry could opine?
Ms. Fleming, do you want to take that on?
Certainly. So I think members, and I don't want to put words in the chairman's mouth, so sir, please correct me if I'm going off track here. So I think what the chairman is looking for is an opportunity for us to review the appeals process. There's a number of steps in the appeals process and time frame, and I think just based upon just general discussions, we take up the appeals season. We have the appeal season every year that runs pretty much from the October to the December timeframe. And I think he has some thoughts about, consistent with Ms. Yee, who has for various stages of the appeals process, some opportunity for us to revisit the appeals process, look for efficiencies, look to ensure that communications, policies, procedures, et cetera, are intact. For my assessment of it, without putting words in the chairman's mouth, I think it's just as we're looking at our improvements in modernization items in general, I think it's just time for us to revisit some of those issues. Consistent, Member Cohen, with what we're doing, for example, on the welfare exemption and a number of other processes that we do. We have a lot of staff, if I can give you background, we have a lot of processes that we've been doing for quite some time. We have a lot of new staff. And so what happens oftentimes is you have processes that are mature, some might call them aged, mature or aged. And so to the extent that you have new people on board, we certainly want to make sure that we are revisiting it in light of those new people with their new fresh perspectives. Also just to look at as the climate changes over time to make sure that we're consistent with, with procedures, with laws, et cetera. So to the extent that some of our processes might be a little bit dusty, we're just taking an opportunity as a part of our strategic plan to go through those processes and just refresh them, either modernize them, improve them, et cetera, et cetera. So I think without putting the words in the chairman's mouth, I think he would just like for us to take a look at it. And again, I think it was consistent with some of the comments that Controller Yee made to Jack in the April-May timeframe, I believe was the timeframe for that comment. So I hope that clarifies. Please let me know if there's any other questions.
No, I think you're pretty much right on point. And actually, one of the things I wanted to do, and I know many of us have looked at some of these cases that have just been rendering recently, like this Verizon case, and not to get ahead of ourselves, but I'm assuming once this appeals process is over, we might have other issues as well that the staff will be looking at. And like I think Brenda was mentioning, I think she's right on point, is to basically just update them and hopefully make them a little bit more responsive and efficient as we look at our processes. Member Stowers, I see.
Thank you, Chair Vasquez. I know at the May meeting, the Controller Yee did bring up the process, but she was not saying look at your process as if there was gaps. She was saying as we move forward with climate change and fires, look at that and how we're doing values, how we're coming up with the values. That was her concern. But from what Ms. Fleming just shared, it's always good to take a look at our processes and see if there's, a need for improvement. It's always, need to make sure everything is properly documented. If that's what you were saying. I don't know about the court cases you cited and how that court case affects our appeals processes, but I will wait.
Thank you. Any other comments or questions? Seeing and hearing none. Ms. Taylor, do we have any written comments on this item?
We do not have any written comments.
Can we check with AT&T if there's any public comment on the line?
Certainly. AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
And ladies and gentlemen, if you wish to make a public comment on this matter, please press 1, then 0 at this time. And once again, that's 1, then 0 at this time. And we have no one with a public comment currently.
Thank you. And I do see a hand from our president, Ms. Dronenberg.
This case slipped by me, the Verizon case. It's a recent case. At what level was it?
It was at the Ninth Circuit.
So it's a federal case?
I'm sorry. Actually, it was in a court of appeal in the 3rd Appellate District. I'm sorry.
So it's already been through the Ninth Circuit or a court of appeal for the state of California?
Yes.
Okay, so it's still got to go to the state Supreme Court. And what was the, in a sentence, what was the outcome of the case? What did they rule?
Mr. Vasquez, this is Richard from the legal department, and if you'd like, I'd be happy to respond to Mr. Dronenberg.
Please do so. I don't want to misspeak on a legal term here.
Mr. Dronenberg, the Verizon case was decided at the 3rd District Court of Appeals for the state of California. So this is a state case. And the time for review for the Supreme Court or for the plaintiffs to file review is over in that case. This case is final, and it's been published, so it is the law in the state. And just in a nutshell, what the Verizon case determined essentially was that when a petitioner reaches a joint recommendation in a state appeal with staff and presents that to the board, they can't later essentially renege on that agreement by bringing suit. And so, as a trial court put it, and I'm of course paraphrasing here, but essentially what they said was that you can't ask the board for a reduction in value, get the reduction you asked for, and then turn around and sue for a value lower than what you had asked for. And so the appellate court had closed off Verizon's ability to bring an action in some particular years.
Would that preclude them from taking it to the federal court?
Well, I don't know that there's any federal issues here that are involved.
Yeah, well, yeah, due process is the only thing I could think of, but all right, thank you very much, Richard. I appreciate it.
You're welcome.
Thank you for your question. Any other comments?
And just, this is Henry Nanjo, Chief
Oh, yes.
Counsel. Mr. Dronenberg, through Chairman Vasquez, I'm sorry. I just wanted to let Mr. Dronenberg, CAA President, know that we do have information on the Verizon case on our litigation roster, which is on our website. And if he has any further questions or his staff has any further questions, Richard Moon or myself would be more than happy to talk to him.
All right. Thank you.
Thank you, Chairman Vasquez.
Thank you. Members, seeing no other comments or questions, Ms. Taylor, if you would please call her. Now, you said you had no written comments on this, right?
Correct. We don't have any written comments, and we have already called for the public comment.
So with that, if we can please call our next item.
Our next item is M1, Public Policy Hearings, Proposition 19 Implementation. Items that appear under these matters provide information to the members and may require board action or direction. There are no planned staff reports or external speakers for this agenda item. However, persons who wish to address the board on this topic as a public comment may do so. This matter will be presented by Mr. Vasquez.
Thank you, Ms. Taylor. With that, I would like to ask, I understand we have somebody on the line on this specific comment that's waiting to make a request. Is that correct, Ms. Taylor?
Well, I believe that our earlier commenter, Mr. Phillips, was possibly the person we had in mind, but we can open up the AT&T line and see if someone's there.
Okay.
AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
And ladies and gentlemen, if you wish to make a public comment, you may press 1, then 0 at this time. Once again, that's 1, then 0 at this time for a public comment on the particular matter. We have no one with a public comment.
Thank you. Ms. Taylor, do we have any other comments from assessors on this?
None that I'm aware of.
All right, and then we will, if there's no other further comments or questions, why don't you please call the next item?
The next item is M2, Public Policy Hearings, Wine Industry and Wine Grower Excise Tax Data. Discussion and possible action on wine grower excise tax data. This matter will be presented by Chairman Vasquez.
Members, thank you. I understand we have 2 speakers on this topic today. Mr. Tim, I believe it's Mr. Tim, is it Schumelizer? I don't know if I'm pronouncing his last name correctly. The Vice President of California State Relations at the Wine Institute, and Mr. John Marco, editor and partner of Goldbergs and Fredrickson. As Ms. Taylor, can we introduce the first speaker if they're available?
Yes, AT&T, can you please open the line for Mr. Schmelzer?
May I have Mr. Tim Schmelzer and John Moramarco please press 1 then 0 so we can open your lines? Please press 1 then 0. Their lines have queued up. They're currently with operators.
Welcome, welcome. Do we have, who do we have on the line now?
They both have queued up. We currently have John Moramarco's line opened. His line is now open.
Okay. John, did you want to start first, or is it Tim? Go ahead.
Actually, I was hoping Tim was going to start. I was hoping Tim would start first, Chairman Vasquez, if
I haven't heard. Is he on the line?
Great.
Let's see.
He is on the line, and he's just with an operator currently.
Oh, okay. Let's give him a minute.
Thank you. And thank you for your patience. His line is now open. Mr. Schmelzer, your line is open.
Okay,
hello.
Good morning, or hi, good afternoon, Chair Vasquez and members. I'm speaking on behalf of Wine Institute today. Wine Institute is a trade association that represents California wineries. We represent about 1,000 California wineries throughout the state. I also have with me my colleague John Moramarco, who is an economist and editor of the Gomberg-Fredrickson report, which produces the economic analysis that's kind of at the root of our issue today. First of all, I really want to thank the board for giving us an opportunity to inform you of the issue we're having today. And just want you to know our objective today is to make you aware of our issue, and it's our recommendation to you to assign this matter to a working group where we may develop an actionable item that the board can take up in an October meeting. To the matter at hand, the issue here is the provision of winery excise tax data. Literally since 1938, Wine Institute, and then following us directly, the editors of the Gomberg-Fredrickson report, have been receiving wine grower excise tax data from the board. And this data has provided the foundation for an economic analysis that allowed the wine industry to make informed business decisions going forward. It allowed us to be responsive to public policymakers as to the status of the industry, and also gave us important data so that the industry could pursue federal funding through grants and such. We've had a terrific relationship with the board over these many years, and were surprised when after, I'm not doing the math correctly here, but 1938 to 2019, things were going smoothly. And in 2019, we were informed that the board could no longer provide this data. After working with staff and then staff, as I understand, seeking legal counsel, the decision was made to provide some of the data that we had been receiving, but the decision was made at that time to anonymize the data. This is essentially the issue at hand. This tax data, a great deal of the value of it is for the industry to see what's happening in different wine regions throughout the state. As I'm sure you can all appreciate, the economics of growing grapes and producing wine in the Central Valley is starkly different from that in the Napa Valley, Monterey, Temecula, San Diego, Santa Barbara, etc. And with this data anonymized, it has really hampered the ability to produce meaningful data that is actionable by wineries. And I also want to underscore why such an analysis is so important. The wine business is one that requires a tremendous amount of planning. Once a decision is made to plant a vine, so say maybe you're going to remove your Cabernet and start planting Sauvignon Blanc or something like that, you may be 5 years from the date you planted that vine till you are actually able to produce wine. And therefore, it's really critical for this industry to be able to forecast directly, understand what the trends are, and be able to make these decisions. And it's because of this provision of data over years that the wine industry has been so successful in California. In fact, California wine industry produces 90% of the wine in the United States. And just to the state of California, we provide over $60 billion in economic value. So we would like to pursue a path where we can get back to the way things were essentially, but we understand that this is a legally potentially fraught manner dealing with privacy issues, and that's why we're recommending that we go to a working group. I wanted to express that we absolutely understand that individual tax data deserves to be private and confidential. We're not asking for individuals' information to be released, but we are hopeful that eventually we'll get to the point where wine company data is released such that we can see the companies and their addresses and such, so that we have the information that we've had in the past in order to produce the economic analysis that's so important to the industry. So that's the basically what we have going here today. Like I said, I have my colleague John Moramarco, who can provide you with some technical detail on that matter. I'm happy to answer any questions any of the board members may have. And I also understand that another colleague of mine, Mr. Michael Miller, with the California Association of Wine Grape Growers, is also available to provide support for the board taking up this matter.
Thank you. Members, I understand we have two speakers on this topic today that'll be speaking afterwards. I'm wondering if we should just wait to hear from the others, and then while we do that, Mr. Smelzmer, if you could go ahead and introduce, I believe it's the John Moramarco, the editor.
You got it. Yeah. So John, if you want to go ahead. So John Moramarco is kind of the economist who the wine industry most looks to, and is the current editor of the Gomberg-Fredrickson report, which is the analysis of this data. So John, if you want to chime in.
Thank you, Tim. Thank you, Chairman, and thank you, board members. Tim really covered the overview very nicely. The reality is that the industry has been receiving this data from the BOE, and we've had a very good relationship with the BOE for decades. And quite honestly, even since the last 2 years where we've been going back and forth with staff, it's been very cordial conversations and everything, but we're just trying to find a solution to be able to get back to where we were receiving the data we'd had been receiving historically. The only thing I'll add, and not getting too verbose, but the BOE data and the way we've used it for decades is a critical component of looking at the industry. We look at other industry data such as Nielsen scan data from supermarkets, import data, grape crush data from California, et cetera, and we put it all together, but it's almost like a great big jigsaw puzzle. And without the BOE data detailed at a geography, location, zip code, industry, producer, it's like we have a big hole in our jigsaw puzzle, and we can't put the whole thing together on a consistent basis. And it's actually caused problems over the last year in terms of not truly being able to evaluate the impact of the fires in Northern California, not being able to adequately impact the COVID. And it's had varying impacts on different size wineries. And as Tim said, we would be very appreciative if we could have a working group put together so that we could discuss how we can get back to what we've been doing for decades with the board. Thank you.
Thank you. Thank you, Mr. Mora-Marco. Members, do we have any questions for either of our speakers before we move forward here?
Mr. Vasquez?
Member, I'm sorry, was that
This
Ms.
is Ms. Taylor? Yes, we
Yes.
do have one more public comment from Mr. Michael Miller.
Oh, yes, I'm sorry, go ahead.
Good afternoon, Chair, members, and staff. I appreciate your time on this issue. And I won't belabor the point anymore, to say other than the California Association of Wine Grape Growers, we very much align ourselves with the comments from John and Tim both. I think they've articulated the issue well. We appreciate that. This data is critically important to wineries and to growers alike, and we'd ask for a favorable consideration of this item in the staff approach. And I thank you very much for your time.
Thank you. I believe that was it, right, Ms. Taylor?
Yes, that is correct.
Thank you. I see a hand up from Member Gaines first.
Yeah, thank you very much. I'm supportive of our working with the Wine Institute to see if we can resolve this issue. It's my understanding that I believe the information from the Attorney General's office was a letter. It was not an opinion. So I think we ought to figure out how we can work together. Of course, we want to be careful of individuals' privacy, but at the same time, give them information they need. I thought it was interesting that John Mora-Marco brought up the issue of fires. We had the Caldor fire in my district, and you know, primarily El Dorado County and part of Alpine County. But I personally spoke to a couple of wine growers that had some real issues in just trying to get to their vineyards while the fire was occurring. There was a lot of lockdown, and people were growers were not allowed to get onto their property and irrigate and things of that nature. And so when I think of this address issue and what the impact of, here we are talking about calamities in a sense, right? In this case, it's wildfire. I think that data is really important. I know just learning, talking to the wine growers, that smoke is a big issue, and that if grapes are exposed to smoke for days on end, that affects the value of their crop and whether they can even make wine with it. So I'm just supportive of trying to move forward to figure out how we can provide the data they need so that they can be productive. And really, we're fortunate that we have such a robust wine industry here in California that is impactful, really worldwide. Thank you.
Thank you. Ms. Stowers, go ahead.
Thank you, sir. To the representatives, I want to make sure I heard you correctly, that you say that what you are getting some data, but you're not getting the name of the wine company and the wine company's address.
That is correct. All of the data is anonymized, whereas historically we've received the information by wine company address, zip code, except for individuals. If it's an individual, we did not receive that data, which we understand, and we understand the privacy concerns there. But if it's a corporation, a partnership, an LLC, that was all received.
Okay. Okay, I follow you. So you did not get the individuals, but you still got a company, which is still the issue that we're having. I think let's work together, but I don't know how we get around Government Code 15619B. And I don't know if we have a quick solution or this is something that we look for law change so that your industry can get it. It could be made public similar to others.
Member Cohen, I think you're finished, Ms. Stowers, right? Okay. Member Cohen.
Yes, thank you. Good afternoon to the speakers. I just have a couple of thoughts. First, I want to just acknowledge the value and the importance of the wine industry to our local economy. I love spending time in the Napa and Sonoma Valley. I am also extremely sensitive to the request for the need for information. And I know it must feel like to the wine industry that the rug has been pulled from under you. For so many years, you've been getting this data, been using this data, and now all of a sudden, you no longer have access to it. And it feels as if the rules have changed mid-game. And so I understand and I can connect with that level of frustration. And so I'm sensitive to the request for information, but also can appreciate the information that's been shared by staff from a legal perspective and what is permissible under the law. Now, it's hard to, I think, accept and acknowledge that for a very long time we have been misinterpretation, or there's been a misinterpretation of the law, and an error has been made. That's the position of the legal staff that they're taking, and they are trying to correct it. With that in mind, I want to support the speaker's request to establish a work group on this issue, but I also want to take it a step further because I believe a critical step forward should also include a legislative solution. Now, I've gone back and forth. I've talked to staff. I've talked to the Franchise Tax Board, who are actually also in agreement with the interpretation of our legal staff's interpretation of the legislation. But it sounds like we need to create legislation to help you gather this information in order to move forward. So I just wanted to go on the record and say that I have taken the initial steps to move in that direction, to work on drafting legislation. So, Mr. Chair, just to sum everything up, I think that the work group is appropriate. I welcome a work group on this issue. Please, I'd be willing to volunteer myself and my staff's time and talent. I think it's important for us to find a balance between the request of the industry and then the privacy rights of the taxpayer.
I appreciate that. That was going to be my recommendation, is that we set up this working group and see if there's what we can do to come back to you all and present hopefully something that's amenable to all parties here, without violating, obviously, the confidentiality issue here between, especially individual. Well, it doesn't seem like the individual is an issue now. I think it's more the corporation and the LLCs. Any personal information they may have included in there. And if people are comfortable with that, well, let me see. I see a hand still up from our Vice Chair Schaefer.
Yes. Thank you, Chair Vasquez. I'm used to going online and looking up the identity of any member of the state bar, or looking at the identity of any owners of private railroad cars. In fact, we see that long laundry list of them in our annual reports. That's all public information. I think I can find out the identity of any economic enterprise just by going online because there's a fantastic array of information there. Uh, as far as getting a street address, that's something a little more sensitive because mom and pop wineries work out of their own residence and they may not really want that. But I'm sure all of them have a P.O. box that they use as a generic address. Um, so I don't think really whoever wants to keep secret the identity of the firms is going to have much luck. Um, Now, as to the amount of wine they produce and whatnot, that has some competitiveness, but even that, a lot of that is on the public information sheets of every industry, whether it's ingots of steel produced or how many chickens you raise. I would like to make a motion that we set up a working group with key stakeholders to work on a solution for the disclosure of the wine growers' excise tax data, and I want to be part of that. Thank you.
Let me ask Ms. Fleming. I know she's been kicking this around a little bit with staff and specifically the legal staff. What's your thoughts in terms of moving forward with the working group and obviously incorporating the stakeholders as well as, I guess if it's a working group, the most we can have is 2 members participating in this, so we can try to expedite this and bring it back as soon as possible.
Thank you, Chairman Vasquez and members. And first, I'd like to take this opportunity to thank our presenters today. We really appreciate your time. It is a bit of a challenging and difficult issue. I do understand that, but I appreciate your patience and even your kindness as we try to resolve this issue. So thank you so much for taking the time out of your day. Members, I absolutely support proceeding with a work group. I think that is fundamentally, as this was introduced, and Member Cohen introduced the work group concept some time back in the 2019 timeframe. I think that's the appropriate forum to study and examine these kinds of issues, allowing kind of a research group in this case, where it really is fact-finding to identify what the issues are in order to do the analysis, in order to offer a path forward to solution it. In this case, fundamentally, it sounds like, based upon the comments from our presenters, definitely they've had a history of getting data. Majority of that data has been in what we refer to as the public domain space, and so certainly a lot of that data is available. To the extent, members, that you consider this item under the work group, it might give you the opportunity to consider some things related to the relationship, the industry professional relationship between the taxpayers whose data we have in our systems, the taxpayers themselves as the winemakers, wine growers, et cetera, and the industry representatives, in this case, Wine Institute. And if there's a natural professional industry relationship there legislatively, to Ms. Cohen's point and others, when you're looking at a legislative path, those might be some components that you can examine closer to see if you could leverage that, right? Because in our situation, we have 2 categories of data, and I think we've had this discussion, the public domain data and then the confidential data. The confidential data is, as you all have said, we do have to protect that, and I think the Wine Institute fully appreciates that. And it sounds like, based upon about 1,000 of the winemakers, companies that they are representing, our database has more than that. But again, it goes down to maybe some of the smaller companies where they're individual wine growers and taxpayers. So as that individual taxpayer, they would that's definitely included in the data that we have to protect. So if you're really looking at an opportunity to move something forward, maybe in your work group, you look at that whole community of taxpayers, wine growers, winemakers, and all of the different configuration of the role players there, establish and define the relationships between those groups and the Wine Institute, and then maybe can carve out a path forward to how do you make that the content that the Wine Institute is looking for, how do you shift that into the public domain? So I think that would be a good opportunity and a good forum to take up this item, members. And then going forward, Chairman, to your question also, in order to establish it, the board would vote on it today, define the scope of what the work group would do. You're not restricted to only 2 members. You could do it as an ad hoc work group. And as an ad hoc work group, you could have it as a small group with 2 members, if that's your pleasure. In that case, doesn't necessarily require Bagley-Keene. However, if you have a broader number of members with at least quorum, 3 or more, then it's a Bagley-Keene meeting. So it really depends, member, how you want to organize it. If you want to have this as public discussion, so that there's full examination, that would be your pleasure. And we can certainly, Chairman, come back to you with more of the specific details going forward in terms of how you organize this meeting. But it would be the board's pleasure to have a motion and vote and take action today to at least establish it with the intent of examining this Wine Institute issue closer.
Thank you. And it was Vice Chair Schaefer, I guess, that actually put out he moved that he would like to establish this working group, and he wanted to be a part of it. And I know Member Cohen was interested. Since we can only have 2, if you 2 want to work with that, I'm comfortable with that. Is that the wish of both the members there?
Yes, Mr. Chair, that certainly is my wish. I also just want to acknowledge that I have an open motion on the floor, and want all the members and the public to participate in the as we examine this issue. So I thought I'd just like to acknowledge that I'd like to make a motion for this work group to move forward. My apologies if I didn't state it clearly.
Oh, okay.
So I need a second.
We had
Chair Vasquez, my motion is
Vice
pending.
Chair had a motion, but neither one's had a second. Let me go back. Vice Chair Schaefer.
Let me withdraw my motion and second Member Cohen's motion.
Okay. So what's the motion, Member Cohen?
The motion is that we move forward with the work group.
Okay. So it's been moved, and then it was second, and I think we're in agreement with that. I don't think there's any opposition, but let me just pause for a minute and see if there's any comments or questions on that. Hearing and seeing none, why don't we go ahead and take a roll call vote on that motion first, and then we'll determine who's going to be the working group. Oh, yes, who's
Chairman
that?
Vasquez, I'm sorry, and I apologize for the interruption, but I would like to just to clarify as a part of the motion before you process the vote. What I heard Member Cohen indicate is that she wanted to move forward with this work group. The question that we would like to be able to confirm or include in your motion or for your consideration is whether that's going to be an ad hoc work group, which means 2 members, or if you want it to full members, because there's a slightly different process. The ad hoc could be 2 members only, but your process in terms of publicly agendizing and communicating that, we would handle that a little bit differently than if it's the full board, where we're operating fully under Bagley-Keene. So just to clarify.
It's my understanding that, I think to answer your question, I think it's a work group because there would be 2 members. And if there's no disagreement, I think the 2 members it looks like that would step up and do this would be Member Cohen. Is that correct?
Let me say this because it sounded like there was more than one. More members were interested. I don't know. I know Gaines has a lot of ag in his district, so I definitely want it subject to Bagley-Keene, so that all members can participate as well as members of the public. Sometimes when you have the work group, other members of our body are not subject to the conversation. The public is not always publicly noticed and brought into the loop. So if we were to properly agendize it as a collective board group, acknowledging Bagley-Keene, that allows us to have full transparency, it allows the public to know what's going on, and it also allows all board members to be able to fully participate, should they choose to. Right, and so the ad hoc committee creates limitations, so that's why I'm shying away from the ad hoc.
Thank you, Member Cohen. I just wanted to clarify, members, because there, as a part of the material that was presented for your work group, there was a distinction between the 2. So just before you process your vote, I just wanted to ensure that you were fully informed about your options.
Okay, so I'm speaking to the 2 I guess the motioner and then the seconder, it sounds like, are you comfortable if we, I guess, change the wording? So we're talking about really a working group that would be inclusive of the whole board as opposed to.
Vice Chair Schaefer, I would agree with Ms. Cohen's sentiments there.
Okay, because I know several of us want to participate. I was just trying to expedite it, but I'm open. Why don't we just do that? Call it I guess technically is it considered a working group as opposed to ad hoc, correct?
Member Gaines has a lot of ag, and I don't have
Yes.
that much except in Imperial County, and so I'd like his input too.
Why don't we do that? All right. So if Member Cohen, if you're comfortable with, can we just state the motion as it's basically a working group that would include all the members, and of course we have to agendize this and give public notice, and then we'll come back and hopefully resolve this here in a timely manner at our next meeting.
That's fine.
Is that good?
Yeah.
And the seconder, I'm assuming is okay, Mr. Schaefer?
Vice Chair Schaefer, okay.
Okay. Member Gaines, I see your hand up.
Thank you. I appreciate the comments by Member Cohen and Schaefer to make it a working group is helpful. I'd like to be engaged in this process. Thank you.
That sounds like it's the best. Okay, so Ms. Taylor, I think you have the motion now, right?
Yes, we have the motion, and we probably should take public comment.
Yes.
AT&T operator, can you let us know if there is anyone who would like to make a public comment on this matter?
And ladies and gentlemen, as a reminder, if you'd like to make a public comment, you may press 1 then 0 at this time. And we do currently have one that's queued up. He's currently with an operator. One moment, please. But as a reminder, ladies and gentlemen, if you wish to make a public comment, you may press 1 then 0 at this time. And we'll open the line of Tim Schmelzer. Your line is open.
Hi, I got disconnected mid-discussion, but I just wanted to say that we support the direction of the board here, and I very much appreciate the generosity of the board members' time in wanting to participate in this and help us craft a solution. So thank you, and I encourage your support.
Thank you. Any other members of the public on the line?
We have no one else with a public comment, sir.
Thank you. With that, Ms. Taylor, if we could just call the roll.
Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Ms. Stowers, do you have a comment?
I'm sorry. I just wanted you to restate the motion because we had a lot of conversation going back and forth. I want to make sure that we're clear on what we're voting on. At least I'm clear.
All right. Okay. The motion that I have is that the board would like to establish a board work group comprised of the full board in order to address data concerns raised by wine growers. Is that the motion?
Like there.
Yes, I think, is that clear, Ms. Stowers?
Okay, great. Thank you. I appreciate it.
All right. From the top, Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
Aye.
Deputy Controller Stowers.
Aye.
Okay, so that's unanimous of all those present. So we'll leave it to Ms. Flemings, and we'll put that together on our next agenda and move it forward. With that, Ms. Taylor, if you would please call our next item.
The next item is N, public comment on matters not on the agenda. Persons who wish to address the Board of Equalization regarding items not on the agenda. Please note that the board cannot take action on items not on the agenda. However, the board can schedule issues raised by the public for consideration at future meetings.
You know, Ms. Taylor, and maybe this is a legal question. If I wanted to go back to items F1A and J1, is it appropriate to do it now or after the public comment?
I think we can do it either way.
Okay. Okay, we can do it either way. Why don't we just continue to see if there's any public comment then?
Certainly, we do not have any written comments. AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
Ladies and gentlemen, if you'd like to address the board on any items on the agenda or not, you may be able to press 1 then 0 at this time. Once again, if you'd like to address the board, you may press 1 then 0 with a public comment. And we have no one with a public comment.
Thank you. Members, before we get to the conclusion, or I guess I should say, this is going to be a carryover until tomorrow, but before we get to that point, I wanted to see if I could make a motion to reopen the vote on both F1A and J1 items to allow Member Cohen to cast her vote on these two items.
I definitely would love for Ms. Cohen to vote, but for the record, clarify what you mean by open the vote, because Controller Yee is no longer here. Will her vote still stand?
Oh.
Oh.
It's my understanding I have to reopen. Maybe I don't have to reopen. Are we able to just bring back the item and allow her to vote or cast her vote?
I believe what I will be doing, this is Ms. Taylor, we would,
yes.
if you all agree to open the vote, I will just recall the item and call for Ms. Cohen's vote, and that will be it.
Okay. I'm
And
fine.
Chairman
Do we need to make a motion?
Henry Nancho, Chief Counsel.
Go ahead.
This is Henry Nancho, Chief Counsel, Chairman Vasquez, and honorable members of the board. Ms. Taylor is correct. You would need to do a motion, and it needs a second. You would then vote on that motion to reopen. If the vote is successful, then you would just Ms. Taylor would reopen both items just to allow Ms. Cohen to vote, or excuse me, Member Cohen to vote, and then all the other votes would stand as is, as cast.
I'll make that motion.
Thank you, Chief.
All right, so then.
Thank you, Chief Counsel. And members,
it sounds like Member Gaines is going to second it?
Yes.
Okay.
Second.
So basically, the motion is to reopen F1A and J1 items to allow Member Cohen to cast her vote on these two items. And with that, if we can get a roll call vote on that motion.
I believe we do need to open it to public comment.
Oh, I'm sorry. Let's do that first.
AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter?
Ladies and gentlemen, if you wish to make a public comment on this matter, please press 1 then 0 at this time. And once again, that's 1 and then 0 if you wish to make a public comment. And we have no one with a public comment.
Thank you. With that, if we can get a roll call vote.
Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
Aye.
Deputy Controller Stowers.
Aye.
Okay, that's unanimous of those present. If we can have Ms. Taylor, please bring back those two items for a vote.
Yes. The first item is agenda item F1A, other tax programs. The motion was to adopt staff recommendations. Member Cohen.
Aye.
Ms. Cohen's vote has been added to the roll. The next item, let's make sure I get the right item, is J1, Administrative Consent Agenda. The motion was to approve the board meeting minutes. Member Cohen?
Aye.
Ms. Cohen's vote has been added to the roll.
Thank you. And I see you have your assistant there, Member Cohen. She didn't weigh in on that vote, did she?
She said aye also.
She said aye,
right after
okay.
I said it, but I muted
Very
it so you
good.
didn't hear it.
All right, with that, members, as we bring this part of our meeting to an end, I just want to thank you again. And now continuing my acknowledgments, as we were talking about at the opening of the meeting, about the
Chairman
Latino
Vasquez.
Hispanic. Oh, I'm sorry. Member Cohen, you have your hand up. You're muted though, I think.
Yes, I know. Yes, before we closed the meeting out, there was another portion of the agenda that I was called away on, and I wasn't able to address. But I wanted to. I don't know if we need to open this up, but it goes back to the legislative report. I just wanted to ask that we request the executive director to draft a letter to the governor. I'm just urging his signature on Senate Bill 539. We heard this in our presentation this morning. 539, and then also Assembly Bill 948. I think that if we have previously sent letters to support while the bills were moving through the legislative process, I think it's important for us to engage with the governor's office during this bill signing period. It's not controversial. It's in line with the work that we do. We discussed this item proactively, and of course, this is always an effort to build relationships with the governor's office. So I apologize for not addressing this specifically in the legislative report, but I definitely wanted to go on the record to make this request. I'm open, if you'd like to take action on the item, then I think we'll have to make a motion to open up the legislative report, take public comment on it, and then entertain a motion to direct the executive director to draft and send these two letters out on behalf of the board. But Mr. Chair, I leave it up to you.
Well, let me ask you, did I hear correctly, remember that you were asking a letter in support of 539?
Yes.
SB 530?
Yeah, urging him to sign it.
But I don't think it's left the Senate floor though.
I think it's on his desk.
539
539 is on the governor's desk.
Oh, okay.
Yes, sir. That is correct, Ms. Cohen.
Thank you. Yeah. And then there's also Assembly Bill 948, which is by Holden. And Holden is legislation is about making sure that there is uniformity and no bias in the assessment of property. This legislation was spurred because there's some folks that were putting their homes on the market, and these were African Americans, and their homes were under appraised, not assessed. I don't want to offend the assessors. It had an under appraisal, which, as you know, when your property is under appraised, you're not able to get fair and full market value for it, which is a loss of money. So the board supported these pieces of legislation. And I just wanted to go, it's just a simple letter. We've done it before, just saying, hey, Mr. Governor, we'd like you to support. That's what
Understood.
I'm asking.
No problem. Let me, in terms of a procedural matter, do we need to reopen that item? Let me look at our legal. I believe we do, huh?
Let's just keep
Chairman
it clean.
Vasquez, Chief Counsel Henry Nancho, we would just recall the matter at this point. I don't believe there is a need to take a vote on it. We would just go back to the ledge report.
Can we, Ms. Taylor, can we go back to the ledge report then?
Certainly. The item we're discussing is K4A, Legislative Research and Statistic Division Chief's Report, Update on Legislative Issues.
And I see two hands of Ms. Towers and Mr. Gaines. Are they both in regards to this item, or is it something separate? It is.
Mine is.
Ms. Towers, go
I
ahead.
think that's, thank you. Ms. Cohen, Member Cohen, it's a great idea to get a letter out on a rush basis and let the governor know how we support it. But since we are talking about the governor, I think it'll have a little bit more weight if it comes from the chairman.
Okay, I'm indifferent.
Ms. Lemmy could draft it and get his signature on it immediately, I believe.
Not a problem. Unless Ms. Cohen, Member Cohen has another strategy.
Well, I think I disagree. I think that, well, okay, it works for me. In the name of expediency, draft it, sign it, send it out, whatever. Let's just get it done.
Not a problem. Member Gaines. I think you're muted, though.
You're muted, sir.
I've got another issue I want to bring up after this.
Oh, yeah. No. Okay.
Well, you know, here's something else. Member Gaines, you're okay with the chair signing this letter and sending it out?
Yes. Yeah. No, I think we need to expedite.
Okay. Great.
Yes.
All righty. So with that,
funny.
Did we need an official motion or no?
I don't think we need an official motion now because it's coming out of your office.
All right.
You got our support.
So, Mr. Nanjo, are we good?
Yes, sir. Chairman Vasquez, the consensus of the board that you can send that out to you through your office.
Will do. All righty. With that, let me have, Ms. Taylor, do we have to close that now, that item?
I don't know that we need to close it, but if we're ready to move on to a different one, I can recall that agenda item for Mr. Gaines.
Yes, let me hear from Mr. Gaines. I'm not sure the actual item.
Yeah, thank you very much. I just, when we had Mr. Naughty give a little update in terms of operations, I just wanted to get a monthly update in terms of what's happening with new hires.
Oh, yeah, good idea. Good.
And then members, if I might, sorry for stepping in Ms. Taylor's lane just a bit. We're going back to item K1E for operational priorities. Ms. Renati.
K1E. Ms. Taylor, I guess if you can call K1E.
Certainly. We're returning to K1E, Executive Director's Report, Operational Priorities. This would be presented by Ms. Renati.
Good afternoon, Chairman and honorable members. As far as our recruitments and vacancies, we're making continue to make good progress on reducing our vacancies. Since last month, we've filled 5 positions. 3 were new to the BOE and 2 were internal positions. As a result, in the last 15 months, we have filled 54 positions. And the department currently has 26 vacancies, and 82% of those are in active recruitment. So we're making very good progress and steadily just bringing those numbers down as quickly as we can. Of course, and before you ask Mr. Gaines or Member Gaines, I'm going to let you know we do have turnover. So those positions, a little bit of a revolving door, whatever the saying is, because we fill promotions and we leave a vacancy, but we are making some progress on getting those done.
That's great. That's very helpful. And part of the reason I'm asking is I just want to make sure we're making progress in filling the vacancies. It's critical for the demands of the BOE. And I know our hands were tied earlier on, and some of the requests that were coming from board members on particular issues, whether it was long-term planning or additional LTAs or the pandemic or working groups, it was very difficult to juggle all that. So I think as we're getting closer to full employment, we'll have a little bit more flexibility as board members to look at those areas at the BOE that we see fit as members and as we decide as a body. So thank you very much. I appreciate that.
You're welcome.
Thank you. Member Cohen, were you going to add something to that? It sounded like
Yeah, I was. Thank you, Ms. Renati, for that information. I'm talking about AB 105. It's the Upward Mobility Act. and I appreciate the laser focus on the priorities. I, however, want to know whether, well, if we're following AB 105, the Upward Mobility Act. I believe one of the significant pillars in that bill relates to the diversity and inclusion in the workplace. I'm hoping that this will fill. I'm hoping that we fill these positions, that we keep diversity and inclusion as a priority. So maybe in the future we can receive some diversity data on these hires, if that's something that's available to us.
Thank you, Member Cohen. And upward mobility is very important, as is diversity, and we can get that information in the future. We do use the upward mobility as a program, and we're looking at ways to expand it currently as a means to bringing more people into the BOE, and then eventually helping them promote into our professional positions. So we are working. Thank you.
Thank you. Any other comments or questions on this? Hearing and seeing none. Ms. Taylor, I guess we can just go back to wrapping this session up.
Yes.
Okay, members, as we bring this session to a close, we will continue this and come back tomorrow. But I wanted to, just thank you all. And in continuing with my acknowledgments of the Latino Hispanic Heritage Month, I'd like to close today's session by briefly highlighting two individuals and their exceptional contributions. One, a happy belated birthday to a dynamic Hispanic Latina leader, Dolores Huerta, who turned a young 91 earlier this year. I recently saw an interview of hers, and when she was asked if she planned to retire from her activism, she simply replied, "Not until my last breath." We should all be so lucky. With the leadership she has shown and continues to bestow upon us, I think we are in great hands. I would also like to congratulate Assemblymember Jose Medina for his recently getting AB 101, the pupil instruction high school graduation requirement in ethnic studies, passed by both the Assembly and the Senate, AB 101, and would add the completion of a one semester course in ethnic studies, meaning specified requirements to high school graduation requirements, commencing with pupils graduating in the 2029-2030 school year, including those enrolled in charter schools. With that, I would like to wish everyone a happy Latino Hispanic Heritage Month, and looking forward to continuing our meeting tomorrow at 10 a.m. And once again, just thanking the members and Ms. Fleming and her staff, who have dedicated so much work on all of our businesses we have handled today. We will address agenda item M3 during tomorrow's board meeting session. And if there's no other closing remarks, we will adjourn, or I should say recess this meeting until tomorrow morning at 10 a.m. Thank you all, and thank you, staff, once again.
Thank you, members. Thank you, staff. See you tomorrow.
We'll see you tomorrow.
Thank you, sir.
Thank you.